1.
The clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
We're ready to hear argument in cause number PD-1182-20, the state of Texas versus Trenton Kyle Green. You may proceed.
Good morning. Brendan Guy from the Gregg County Criminal District Attorney's Office for the appellate of the state of Texas. That's for 12 minutes at the front, 8 for rebuttal. May it please the court, Mr. Bottle. This is primarily a case about statutory interpretation, specifically in regards to the forgery statute, section 32.21, and specifically within that subsection ETAC1, the so-called value ladder provisions. The Court of Appeals in their ruling in this matter indicated that, held that the value ladder provisions are mandatory, essentially that if the state has reason to believe the offense was to obtain a property or service, the state must plead and charge that. The state disputes that ruling. Our contention is that the value ladder provisions of ETAC1 represent just one of the methods that the legislature has given us to charge a case under the forgery statute, and thus it falls within a prosecution's discretion whether to plead ETAC1 or one of the other sections.
Mr. Guy, what do you make then of the introductory language on the provision that you're relying upon that says subject to E1? How do you explain that if you think that this is just a discretionary call for prosecutors to make?
Well, Your Honor, the subject to language is important for the state's interpretation of the statute to even work, because absent that language, there would be ambiguity in a charge that alleged, say, both that the forgery was with counterfeit money, as in this case, and that it was to obtain property or services of a certain value, as to which section controlled. What the subject to language does is establishes that if the charge is pled in such a manner where it could fall under subsection C, D, E, or ETAC1, then ETAC1 controls in that circumstance. So it's not a directive to require the state to go under ETAC1. It just shows, though, that if the state pleads ETAC1, then that is what the value ladder is. That is what the punishment range on the offense is. It's going to be governed by that statute, not by subsection D, not by subsection E. What's particularly interesting about the subject to language is the absence of it in subsection B, the provision that sets the default nature of what a forgery offense entails, and also the absence of subject to language in subsection C, which sets the default punishment range as a Class A misdemeanor. If the legislature's intent with this statute was in fact to basically make the value ladder apply in all cases that were to involve property, to obtain a service, logically they would have included that same subject to language if that language was meant to establish the directive nature of ETAC1. They would have needed to have included that in subsections B or C as well, to show the ETAC1 controlled for forgery cases charged in there as well. In the absence of that, under the Court of Appeals' interpretation, basically the state could get around having to use ETAC1 simply by alleging the offense under, just as a straight offense under subsection B, subject to the subsection C punishment range. Now, that's not a felony punishment per se, but it's still, if the offense was a Class C value, item, basically, that still bumps it up all the way to a Class A, which is still a fairly substantial punishment bump from a $500 fine all the way up to potentially a year in the county jail. And when you combine the provisions in the statute that allow for enhancement if the victim was an elderly individual, you could even potentially, going entirely under subsections B and C, and ETAC2, get the offense all the way up to a state jail felony without ever involving ETAC1. It seems unlikely the legislature would leave that sort of loophole in the statute if their intent truly was to make the subject to language controlling, to make ETAC1 controlling for all small dollar forgery offenses. So it's much more logical that their purpose was just to establish with that language that ETAC 1 controls if it's pled, but the charging decision, whether to plead ETAC 1 versus subsection C, D, or E would still fall to the state.
Well, in light of that, do you have an opinion about what would happen if, for instance, the state did not charge the ETAC 1, did not allege that in its indictment, but at trial, the defendant took the stand and testified that he, in fact, did have the purpose that is described by that provision? Would the defendant then be entitled to ask the trial court to submit a lesser included offense instruction, for example?
For a lesser included, of course, it would have to they would have to be able to show that there were positive facts that they were only guilty of the lesser included. That would theoretically be difficult in such, because if the state's evidence, for instance, showed that, say, the charge was a counterfeit currency accusation in this case, the defense would have to be able to basically, to get it under the purview of ETAC 1, they would have to show that there was no way they could be guilty just of the counterfeit currency accusation. And of course, if they disproved that, they would be entitled to an acquittal altogether. There might conceivably be fact circumstances where they could be entitled to a lesser included offense. I can't really think of any offhand, but ETAC 1 would be a separate offense than E and D in that regard. And so in that sense, yes, there could theoretically be circumstances where a lesser included could be appropriate. Now, the Court of Appeals, to justify their decision, that they also relied heavily upon the in pari materia doctrine, but the state believes that doctrine is not applicable as to this specific statute for a couple of reasons. First of all, at least from my research, the in pari materia doctrine has only ever applied with conflicting statutes. I'm not aware of any case where it's been applied within a dispute within a single statute. I think that would be stretching it well beyond what that doctrine was intended for, to start applying it to conflicting subsections within a single statute. But even if we assume in arguendo that the in pari materia doctrine can be applied to a conflict within a single statute, there's specific reason in this case to believe the legislature did not intend the in pari materia doctrine to apply, and that's the continued presence of 32.21G within the statute, which is language that holds that if conduct under the forgery statute could be charged under this statute or another statute, then the state has the discretion to go under either statute. The language of that nature has always been held by this court to show that to represent the legislative intent not to apply the in pari materia doctrine to a case. It's indicative of the legislature wanting to give the state broad discretion in a matter. So obviously, if the court or if the legislature's intent had been to narrow the state's discretion on this matter, they would not have included 32.21G. I believe my brief indicates how, due to the presence of that statute, the state could easily, on any forged check case, could actually charge that still as a felony, even if it was for a Class C, a Class B, a Class A amount, simply by, instead of charging it under forgery, using 32.21G, which would allow them to instead charge the offense under 32.51 for possession of fraudulent identifying information, which would be present on pretty much any check case, and thus could still essentially charge a Class C forged check as a state jail felony just by using 32.21G.
I'm just kind of curious. I mean, the legislature went to the trouble of amending the statute to provide a lesser offense in cases where defendants, normally, if they were doing something for under 100 or under 20, they would have the benefit of a misdemeanor. The forgery statute absolutely precludes that, at least prior to the amendment, where any type of forgery was a felony. Why would they go to that trouble? And if they in fact passed it into law, which they have, how could the defendant ever take advantage of that statute that the legislature has made a misdemeanor?
Well, sir,
if you're using your discretion, you pretty much preclude them from getting any type of a lesser offense.
Well, the whole point of giving prosecutors discretion is to trust in the prosecutors to do the right thing, to pursue their duty to see that justice be done. There could certainly be cases where the prosecution either to facilitate a plea or simply because they think it's the right thing to do would want to pursue the misdemeanor option rather than the felony option. And there's certainly numerous other statutes that potentially give the states the option to choose between a felony or a misdemeanor. The theft statute, for instance, if I steal a bag of pennies worth, a couple of dollars, that would typically be a Class C offense. But the theft statute also has a specific provision where theft of copper is a state jail felony. Theoretically, a prosecutor then could, faced with that situation of the Class C amount of pennies stolen, could instead charge that as a state jail felony. What would keep the prosecutor from doing that is not anything in the statute itself. It's just the good sense of the prosecutor. And if the prosecutor doesn't show good sense in that regard, if they recklessly overcharge, ultimately the remedy is for the people at the ballot box to take action to remove that prosecutor that's not doing their job to see justice done. But the mere fact that the legislature wanted to give prosecutors an expanded tool set, to give more options, that they've recognized that in certain cases, a misdemeanor option might be the more appropriate and just result, does not mean that the legislature intended to forego prosecutorial discretion in this matter. If they wanted to do that, they would have either put explicit corrective language in the statute, or they certainly would not have included 32.21G, which gives the prosecutors the ability to go beyond the forgery statutes.
Mr. Guy, can I ask you, do you think there's a difference between the intent to defraud and harm and the attempt to get property or service? Or maybe the attempt to get property or service now is limiting the intent to defraud or harm?
I would say it's an additional element that is added if the charge is pled under TAC 1 to show that it was done to obtain property or service, or to attempt to obtain property or service. That's why it appears in that specific language, and it isn't present anywhere else in the statute, which is why forgeries can still be charged under subsections B, D, and E without having to prove that element, which of course gets into the fact as to why the state's alternative argument is that the Court of Appeals also erred by quashing the indictment because we alleged a complete offense under 32.21E, and thus the defendant's motive for committing the offense under that subsection is not an element of defense and was not required to be pled in the indictment, and thus it should not have been quashed.
Thank you, counsel.
Go ahead, Judge Keller.
You're running into your rebuttal time. Did you want to save that time?
Yes.
Okay.
So if there's no further questions, I'll save the remainder of my time for rebuttal. Thank you.
Good morning. Thank you for having me. May it please the court, Mr. Guy. I'd like to start by saying James Madison in Federalist 51.
Counsel, could you state your name for the record, please?
My name is Vincent Botto. I represent Trenton Green in this case.
Thank you.
Thank you. Sorry. I'd like to start by saying James Madison in Federalist 51 speaks to discretion within the government. If men were angels, we would not need government. If angels governed, we would not need checks and balances on government officials. In a Republican government, the legislative authority necessarily predominates. So even in 1788, James Madison knew, and our founders knew, the facts dictate prosecution and not the whims and fancy of an elected official. Our indictment says, with intent to defraud or harm, the defendant made a fake $20 bill. So that's what the state has to prove. The state has to prove in some way, shape, or form, a defendant with a fake $20 bill had to defraud or harm another person. Starting there, I think, is a good starting point. The state says it's the state's discretion and the good sense of the prosecutor should prevail. Well, the good sense of the prosecutor in this case is continuing to keep a $2 cigarette lighter as a third-degree felony with up to 10 years in prison as potential punishment range. That's a little frightening based on the new language of the statute. The new language of the statute comes after SB 1824 was enacted, and we get the subject to language in section 3221, which I believe, and the Court of Criminal, the Sixth Court said, is directive explicit language mandating the state of Texas how to proceed under this statute. I'm confused by the state's continued reliance on this theme that there is no explicit directive language in the statute, when there is, and it's new language. So we know it's dictating and directing us somewhere. And that new language is represented in subsections D and E that say subject to subsection E1. I don't know how that is an explicit and directive language. And then also it says, if shown at trial, the attempt to pass, you go to the value ladder, right? If it's shown at trial that you use this counterfeit document to obtain or try to obtain a property or service, go to the value ladder. Those are two very explicit statements made by the legislature. The state wants to proceed as if this language does not exist in the statute. They even said in their brief, prior to 2017, the language didn't exist. Well, who cares? This is after 2017, and the legislature has made a statement to dictate what we should do. So that leads us to the statutory construction and legislative intent argument. And in the state's brief, they even quote this language. The Texas Government Code 312.005 tells us that we must diligently attempt to ascertain the legislative intent by focusing on the actual text of the statute. But then the state wants to ignore the text of the statute, and that confuses me. If we go to the Pilgrim case from the Texas Supreme Court, we learned that subject to is subordinating language, meaning that when you put subject to in a subsection of a statute, it subordinates that particular subsection to whatever it cross-referenced, which means subject to subsection E1 subordinates D and E to E1. I'm not sure how else to read it.
Is it your view that what E-1 does is creates, in effect, an exception to the more general law that the state intends to rely upon here? So that, in fact, the state, in order to provide a sufficient indictment, must plead and prove the absence of what's provided for in subsection E1?
Your Honor, I absolutely believe that, and you can use certain terminology. If you want to use exception, that's fine. The Sixth Court said it created a new element of purpose. I think that's true too. And to speak to, I believe it was Judge Keel who brought it up. Is this a limiting factor, this new language, the attempt to get property or obtain property? Does it limit the intent to defraud or harm? I don't think it limits it. I think it is a way to explain it. And the legislature has told us, if you're going to explain intent to defraud or harm via obtaining a good or service, then we want this to be part of the damage value ladder, as we've seen with every other property crime in Texas.
What would be wrong in your view with, if it would be, I don't know. What if the court were to decide that the state could charge the greater offense without alleging the subsection E1 purpose in the indictment, but the defense could make sure that evidence of that purpose was introduced at trial and would be given the opportunity, therefore, to ask for the submission of that lesser included offense instruction so that the jury could then consider it?
Your Honor, I agree that is a way to go. I think there's inherent trouble in that for this reason. If I, as a defense attorney with my defendant, get an indictment that does not say attempt to harm or defraud, and it doesn't say to obtain a property or service, and I think, well, my guy passed the $20 fake bill to get a $2 cigarette lighter, I'm going to be able to get this as a lesser included. And the state comes in, and Mr. Guy has put strange notions in his brief about different countries doing different things to take down a counterfeit bill and take down the economy. If there's another way to show intend to harm or defraud, I need to know what that is as the defense attorney so I can prepare our defense. If it's just willy-nilly and they can come in and prove whatever they want, I'm really I don't know what to do there. I don't know how to proceed. I would not be on notice. And I think the charging document would fail under this court's ruling in Barbanel and under the Code of Criminal Procedure 2111, where the judge has to know what sentence to pronounce when that person's found guilty at the outset. And we need to know what the facts are going to be so we can defend it. That would be my answer, Your Honor, to that question.
So, counsel, don't you think it's a little odd that if I have a forged $20 bill in my pocket, it's a felony, but the minute I put it on the counter, it becomes a Class C misdemeanor?
That's a great question. I actually was talking to another prosecutor in a different county about that, and she mentioned that to me. And I hadn't thought of it that way until that conversation with her. What I would say is this: there's still another element that we're forgetting, and it's the intent to defraud or harm. And we can't ignore that, right? So if a guy is carrying around a fake $20 bill, he's not actually committing a crime unless the state of Texas can prove he intended to defraud or harm someone with that $20 bill. I don't know how you do that unless you're really close to a store and you have your hand in your pocket on that $20 bill. I don't know. But to your point, Judge McClure, I'd be curious to see how the state proved the intent to harm or defraud just because I have a $20 bill in my pocket that may or may not be real, right?
Well, so let me just ask a second question. What if you're at the bank, you're just going to deposit the $20 bill, you're not obtaining a good or a service. So don't you think it's kind of weird then that that's a felony? It's a felony to deposit a $20 bill, but it's a traffic ticket basically to buy a $2 lighter?
I actually think in that scenario, you would fall under the attempt to obtain a property or service. And I think that would count as money since you would be realizing $20 in your bank account. I think that would qualify as obtaining a good because or attempted to. At that point, you could prove attempt because he's at the bank, he's ready, he's got a deposit slip, and that would actually be property under the code, I believe, because that would be money that you realized. That would be my argument there. But I do agree with you. It's interesting if the state could prove some other way to intend to harm or defraud, possession of that document with that extra proof would be a felony. But I'd be curious what that extra proof would be. And the state can get there.
There's a lot of ways to prove that, many different ways you could do that. He could have made admissions, you could have extraneous offenses. There are a lot of different ways to prove that. But is there a difference between the intent to defraud and harm and obtaining service or property?
Your Honor, I believe there is a difference because there are different ways to harm or defraud. As you just mentioned, well, you mentioned there are different ways to prove it, but I think there are also different ways to harm or defraud. And I'll give credit to Mr. Guy. He gave us a lot of those reasons in his briefs in the lower courts, which you all have. So yeah, I mean, if you're not going to pass it, but you're going to use a deed, for instance, to cloud title, well, that's something that's not going to be passing to obtain a good or service, but it's going to be attempting to harm or defraud.
So is this, go ahead.
No, you go ahead, Judge Keel.
Well, I was just going to say, so is the state going to be obliged then under your reading in the statute to allege a different purpose for these kind of cases?
Judge Keel, I believe that is true. And I believe under this court's rulings in Barbanel and the Code of Criminal Procedure, they have to do that because we need to know what our punishment range will be. We need to know if we're proceeding under some other way to show intent to harm or defraud under D&E, or if we're proceeding under subsection E1, where they attempted to pass for a good or service. And I need to know that at the outset as a defense attorney. The defendant needs to know, the judge needs to know, so he knows what sentence to pronounce. That falls directly in line with the Barbanel line of cases.
Well, I'm sorry, go ahead, presiding judge.
So, no, I forgot what I was going to say. You go ahead.
But often they're going to overlap, aren't they?
I'm sorry, Judge Hervey. I don't think so. I don't know when clouding title is going to overlap with attempting to obtain a good or service, or I'm not sure when walking into the gas station trying to use a fake $20 bill for a cigarette lighter will be some other way to harm or defraud. I think more often than not, you're going to be in 32E1, 3221E1, which is where the legislator wanted them to go, as they said in their analysis of the bill, the author's analysis of the bill. Bring this in line with other property crimes. That's what they said to do. And I think that's what they did with the language.
Okay, here's my question. So if the indictment charges intent to defraud or harm, you file a motion to quash and the trial court says, yes, the state has to allege something on the value ladder. And the state thinks this isn't a $20 bill, though. This is something like some notarized document. And the state thinks it's not with intent. There is no intent to obtain a property or service. And they don't think that they can prove that. But now the indictment charges that. So do they have to prove that? I mean, do they have to prove something they don't think they can prove because they don't think it's with an intent to obtain a property or service? And then they're out of luck because it's in the indictment.
Well, if they put it in the indictment, I would expect the state to be able to prove it. As a prosecutor of 10 years, I would want to prove what's in my indictment. However, I don't think they have to put that in the indictment. They just need to give me the way they intend to prove intent to defraud or harm. If it's obtain a good or service, we go to 32E1. If they show me the other way they intend to prove intent to harm or defraud, then we're under D&E as they are normally written. I don't know if I understood your question.
Yeah, I probably didn't ask it right. So it is odd, though, to require that allegation of facts in the indictment, how much the property is worth. And then the statute is also strange because it says if it's shown on the trial of an offense. So none of this matters until it's shown at trial, right? So why do you get to know ahead of time what the state is going to show at trial when that's a fact as opposed to or an extra element? Is it just so you're on notice of what you have to defend against?
Yeah, I appreciate the question, Judge Keller. And I think Aliva speaks to that very well, right? When we talk about DWI third or more, and the third or more becomes an element of the offense, same with assault family violence enhanced. So this is very similar to that. And the Sixth Court laid it out very well, I think, in their opinion, where Aliva says when it becomes part of the circumstance of the offense, you have to allege it. And I don't know any other way that this isn't a circumstance of the offense when you're trying to prove intent to harm or defraud, and you can either prove it through 32E1 when they attempted to pass it for a good or service, or they attempted to harm or defraud a different way that we need to know about so we know we're under 3221D or E. So I think Aliva answers the question and that line of cases, especially since the statute doesn't discuss punishment or punishable by and just says this is a state jail felony. This is a third degree felony under 32E1. This goes to the value ladder. So there's no punishment recommendations in there telling us it's a sentencing issue. It's absolutely telling us it's a fact issue, an element of the crime. When they added this language, the legislature added that purpose element into the statute. So with my 3 minutes, 52 seconds, I'll end here. The law changed for a reason, right? That it wasn't just willy-nilly, here you go. They actually thought about it. We know that based on their bill analysis, which you have. We know that through the authority of the actual language they put, explicit mandated language to tell the state how to act, subject to subsection E1. I don't know how to get around that. Judge Keller, to your point, I'm not saying it's not a curious statute. I'm not saying that. What I am saying is the language is clear what we should do here. And if someone tries to attempt to pass for a good or service, we have to go to E1. And I need to know that's going to happen before I get into a trial situation. So we're just asking, as the defense bar and the legal community, we're just asking the elected DAs around the state to follow the law as it's now written. That's all we want. And I think they need a little nudge. So we're asking you to give them that nudge.
Thank you, Counselor.
Thank you.
It seems it's hard to rationalize an argument to follow the statute as written with then a claim that a whole new element can be inserted into 32.21E or 32.21D for that matter. Nothing in the plain language of either of those subsections establishes an element the state has to prove the defendant's motive for why they committed the forgery with those particular items. And it would be extraordinarily unusual for the legislature to have imposed such a motive element upon the state. That's not something that the legislature normally requires the state to prove in cases. There's no reason to believe they intended to require that in this case. 32.21E and 32.21D are exactly the same as they were before the 2017 changes to the statute. If the legislature had wanted to add a motive element into those beyond just the intent to defraud or harm that's always been present, if they'd wanted to add an additional motive as to explaining how specifically that was going to be done, what the defendant's purpose was, they could have certainly put it into those statutes at the time they made that amendment. They did not do so. So the plain language of the statutes suggests that was not their intent. Furthermore, it's not necessary to write such an element into 32.21E or D to make the statutes work. We know this because these statutes have functioned for decades. They worked just fine before 2017. They did not need to have that motive element written in them before to function. There's no reason to believe they would need that now to function.
Counsel, isn't the addition of this language, I mean, you say it worked fine prior to 2017. I mean, maybe that's what the legislature was thinking, is this is working way too well. And so what we're trying to do is keep 18-year-olds from getting arrested at CVS for trying to buy, a cigarette lighter. I mean, isn't that just as reasonable of an argument or interpretation?
Well, Your Honor, if that was the legislature's intention, and again, I'm talking specifically about subsections D and E here, then why would they leave those sections in the statutes unchanged and leave them in the form that makes it a felony to pass a forged check, that makes it a felony to pass forged counterfeit money? The legislature chose to leave those provisions in the statute. They presumably did that for a reason, and that reason is entitled to deference and respect on judicial review. As for the E1 and possibly the legislature wanting to take those type of cases out of the felony courts, again, if that was the legislature's intent, it just seems that they would have drafted this statute very, very differently. They wouldn't have included 32.21G, which gives a way around E1. They wouldn't have given 32.21B and C and made them not subject to E1. They wouldn't have left subsections D and E as felony offenses standing on their own. If the legislature had unambiguously wanted to make it to where forgery cases were not going to be felonies, or at least wouldn't be felonies except for when the value of the property was sufficiently high, they could easily have structured the statute in that way. There's numerous other examples of how the legislature has done this. There are statutes where they have specifically directed the states, if certain facts are met, you have to go under this particular section. There's the theft statute, which basically makes the value ladder the default assumption as to how theft cases are pled, and then has certain exceptions written into it where the legislature thinks is appropriate. But the value ladder there is functionally the default of how it's done. The legislature pointedly did not do that with the forgery statute because, again, subsection B and C don't even touch the value ladder at all. And that is the default level for how a forgery offense works, absent the state pleading additional facts, subsection D or E, that it was a certain type of writing, subsection E1, that the forgery was done to obtain property or service, and that the value was at a certain level.
Mr. Guy?
I'm just curious, Mr. Guy. Go ahead, Judge Erie.
Well, let me go ahead and ask the question. So here's what I'm wondering is let's say that we agree with your position, say that your indictment should stand and your case should be permitted to go to trial. And then on the trial of that case, the evidence unmistakably, beyond a reasonable doubt, demonstrates that the purpose was to obtain a good or service, right?
Yes.
What should happen in that case? Let's say that the state, even in the middle of the trial, concedes, to the jury and to the court, yes, this was to obtain a good or service, but that's not been pled in the indictment. What should be the result at that point?
Well, Your Honor, the state's contention, of course, is that we have the discretion to choose whether to charge under subsection E or subsection E1. So if we pled it under subsection E, that it was to obtain a good or service doesn't even enter into it. The case hasn't been charged under E1.
Well, I want to interrupt you if you don't mind, because the language of E1 doesn't talk about whether or not it had been pled. It said if it is shown on the trial, then its terms take effect. So I mean, that's what I'm talking about. I'm not talking about discretion that the state has to charge the greater offense, because I'm assuming that we decide, for example, in this question anyway, I'm assuming that we decide that is something within the discretion of the prosecutor. But then you get to trial, and again, it is shown on the trial that the purpose was the one provided for in E1. What do we do then?
Well, sir, statutes never really say if it is pled. I mean, subsections D and E, for that matter, don't say that if the state pleads that it's this type of writing, it becomes this. It's just understood that that's how it works. But if the court did take the view that E1, if facts are shown in trial, controls, then at that point E1 would presumably be treated like kind of like the sudden passion defense under the capital murder section 1902, where potentially it could lower the punishment range at that point. Obviously, it couldn't raise the punishment range if the property value was shown to be above a state jail or a third degree, because that anything that raised the allegations would have to be pled in the indictment to apply. So in that sense, if you took that view, I think treating it as a special defense that could be invoked by the defense would be the appropriate way to go. But of course, the state believes it's entirely discretionary whether to plead subsections D, E, or ETAC 1. And if we plead E, then E controls, and the ETAC 1 elements are not an issue at all. And thus, the case should just proceed under subsection E, because that's what the state pled. That's what the evidence at trial proved. Right up there. We've got about 5 seconds left of it. So if there are no other questions, I'll just finish up there. Thank you.
Thank you, Counselor. Perfect timing. The case is submitted and the court stands in recess.